Sempozyum programımız çok kısa bir süre içerisinde başlayacak. Sizlerden salona gelmenizi ve yerlerinize oturmanızı rica ediyoruz.
Now I'm on channel 2.
Yeah, can you hear me?
I-
Yes? You need to maybe go out to
yeah,
get
no,
it?
it's okay.
Okay, okay.
Sayın Danıştay Başkanı.
distinguished President of the Council of State, distinguished Minister, distinguished members of the Judiciary, ladies and Justice, and the strengthening of the institutional capacity of the Council of State, co-financed by the European Union, the Republic of Turkey, and the Council of Europe under IPA. We are today hosting a distinguished minister, distinguished members of the Judiciary. The project was initiated in 2019 December, and until this point, we have actually undersigned many important activities. The Ministry of Justice, and amongst the stakeholders, we have the Council of State, the Council of Judges and Prosecutors, regional administrative courts, the administrative and tax courts, Turkish Union of Bar Associations, the Ombudsman Institution, and administrative justice are the beneficiaries. The main target is actually providing the independency of the administrative judiciary and increasing its effectiveness, and increasing the trust felt towards administrative judiciary towards the awareness raising. The project has also focused on the strengthening of the institutional capacity of the Council of State, as well as supporting the administrative judiciary reform and increasing wages. I would now like to invite you to 1 minute of silence that shall be followed by the national anthem in memory of the founder of our republic. Of the Judiciary. Now I would like to invite the Deputy Head of the Delegation of European Union to Turkey, Councillor Madam Eleftheria Pretzinu, to
Distinguished President of the Council of State, Honorable Minister, distinguished representatives of the Turkish judiciary and of bar associations, distinguished representatives of the Council of Europe, dear guests, ladies and gentlemen, the European Union project implemented together with our Turkish partners and the Council of Europe. The project was designed and launched in 2019, and the main aim in private parties and institutions of public authority, and also to strengthen the administrative, touched upon different stages of the administrative justice chain, and established a platform of discussions on problem areas. The real added value of the project is its single strategic approach, pre-trial resolution mechanisms, and the judicial actors. Our common conviction is that only coordinated actions among all stakeholders may advance reform of the uniformity and thus increase the overall public confidence in the judicial system. By the Council of State, the Ministry of Justice, the Turkish Ombudsman, the Human Rights and Equality Institution, public institutions like the Ministries of Health and Education, the Social Security, and the Union of Bar Associations. As we approach the final stages of the implementation of the project, our achievements include a comprehensive contributing to Turkey's judicial reform strategy and bringing forward benefits for the entire judicial system of the administrative judiciary by promoting good public administration decision-making and simplification of judiciary and court staff and promote unity of case law. Some of the recommendations of the roadmap are being implemented. Let me stress, though, that full implementation of the roadmap recommendation and bring concrete benefits to the citizens. This concerns in particular the need to apply the legal adjustment recommendations. As the efficiency of judicial systems is a necessary condition for the protection of every person's rights. Turkish law requires judicial review of the activities of the administration. Judicial review in administrative law is not only a matter of resolving conflicts between parties, but it's also an effective legal boundaries. Effective judicial control is not only a matter of distribution of justice, but also a matter of supremacy of law, constitutional government, legality of the administration, and sound protection of rights and freedoms of the people. And the respect for the judgments of administrative courts by the state actors and the ruling power is an indicator of its approach to the values of equality and dignity. For that reason, we believe that improving an administrative and more equal. Today's symposium provides an excellent opportunity to exchange views and experiences of the reforms and procedures in administrative judiciary systems of other countries. Separate jurisdictions, like here in Turkey, others are embedded in civil and criminal judicial systems. The common denominator for all these systems is to provide fair judgments to conflicting parties by respecting the right of everyone to a fair and public hearing. So, by concluding, let me again thank all who contributed to this project, to the successful implementation of this project, and let me wish all of you fruitful and interesting discussion.
Sayın Pertsinidu'ya teşekkürlerimizi
Minister of Justice, Mr. Bekir Bozdağ.
Saygıdeğer Danıştay Başkanım,
Distinguished President of the Council of State, esteemed Ombudsman, esteemed Deputy President, President and members of the President of the Judges and Prosecutors Council, distinguished President and members of the Council of State, distinguished guests. I also would like to greet you all with love and affection and the mercy of the Holy Allah. Esteemed guests, we will be carrying out the International Symposium on Administrative Judiciary, and within this symposium, within the framework of the project on improving the effectiveness of administrative judiciary and strengthening the institutional capacity of the Council of State, valuable views will be shared, and I'm sure that both the Council of State and ourselves as the Ministry of Justice and also the while Turkey is taking its steps in the area of law, it is driving on its own accumulated knowledge and experience, but also benefiting from the accumulated knowledge and experience in other countries in European Union or follow up all the international developments. We have a statement on comparative law, which is a new department, and here we have well qualified legal professionals who can speak different languages, and they are assigned to follow all the developments in the field of law in Europe and also in other countries, to closely follow them up, to translate the laws in those countries into Turkish, and to follow the legal issues that are being discussed in the parliaments of these countries, to convey them and transform them into the Turkish system. Our aim is to find what is good wherever they exist and to bring them closer to the Turkish judiciary, both in the area of its same approach, and we will continue to follow the same approach from now on as well. The step-by-step implementation of the Turkish judiciary reform strategy will help both strengthening the rule of law into its importance. As Turkey, strengthening administrative justice and ensuring that judicial review is effectively carried out against all the acts and actions of the public administration. For this purpose, we have undertaken significant reforms. As is known very well by those that are here, according to Articles 129 of the Constitution, by introducing exemptions to these issues, such as discipline, scope of administrative justice. And the Constitution was giving the Parliament the authority to exclude the warning and a reprimand. We have now changed it into a constitutional provision that no disciplinary penalties can be excluded from the scope of judicial review. And now the Parliament is banned from excluding these from the scope of the administrative justice. This is both in terms of our administrative justice and in terms of our understanding of being a state where rule of law applies, is very important. Having such a door open, and now we have closed this door fully in a way that no one would be able to open it in the future. In the area of administrative justice in Turkey, we had a dual practice to deal with those kind of cases. And as you know, on the other hand, we had our Council of State, and it seemed as if there were two different types of administration. So we have also abolished this dual system. The military high administrative court had administrative justice that has a single law and has a single high court. Now our Council of State and our administrative courts are carrying out their duties according to this principle. This strengthened our understanding of being a state where rule of law applies, and also further established public's view of the state, ending separate practices and judicial practices for military. We've also taken other steps. Although in our constitution we have the expression being a state where rule of law applies, we had certain judicial practices which were not actually in line with this principle, and we have also lifted them one by one. Just to give some examples, according to our constitution, orders and decrees and now this has been changed, and all of the orders and decrees that have been ex officio signed by the President are open for judicial review. And according to a former provision in our Constitution, against acts taken unilaterally by the President, there were no judicial reviews. This has been abolished as well. And right now, judicial avenues are open to the end for actions unilaterally taken by the President. And in the President who would be responsible for the acts and actions taken. But right now, the President, both in a legal, civil manner or criminal manner, is fully responsible for the actions taken. There would be no judicial remedies against the decisions of the High Military Council, and now it is available. And also, judicial review is also available for the decisions of the Council of Judges citizens had a conflict, these were constitutional provisions that prevented them from applying to the courts. In the last 20 years, Turkey, in its constitution and laws, has actually changed these provisions in the constitution or the law in line with the principle of rule of law. And currently, there are no acts or actions could be taken by the public administrations that would fall outside the scope of judicial review. And hopefully, in the upcoming period, with regards to strengthening of the administrative judiciary and having effective and efficient acted in a stronger manner in line with our constitution and the laws, we are determined to take the necessary actions to reach these objectives. As the ministry, appeal mechanism for the administrative justice as well. When the administrative appeal mechanism entered into force, this reduced the workload of the Council of State and also ensured reasonable completion of the cases in a reasonable period of time, and also ensured that the role of the Council of State as a case law unit in 2015 followed the previous system, and the number of cases that were received by the Council of State was 267,381. And in 2021, where the appeal mechanism is in force, the number of cases received by the Council of State is 101,270. And the difference between the two is approximately 6 cases received by the Council of State, or in other words, the reduction rate in the workload of the Council of State is 62%. Of course, this means that the chambers of the Council of State as a court that ensures unity in case law, but also ensured that the trial procedures in administrative justice were completed within a reasonable period of time. But at this point, I also should not be understood, and there are some who try to create a perception as if a new layer of judiciary is created between the first instance courts and the Council of State, and the first instance courts and the Court of Cassation, and prolonging the process. It is actually ensuring that the cases are completed shorter than the target periods. And I would like to underline this fact because introduction of the appeal mechanism is of extreme importance to increase the effectiveness of our judiciary. Accusing the appeal system or bringing criticism, achievements, the concrete information that we have regarding the appeal mechanism, because when they are correctly considered, many of the criticisms against the appeal mechanism would be unfair, and those who are criticizing would be able to see this if they were to look. In order to identify the problems encountered by the appeal mechanism, we have established commissions who are carrying out their work, and when they are completed, we will also implement one by one all the solutions put forward be taken to make the appeal mechanism stronger. On the other hand, alternative dispute resolution mechanisms are of great importance. Our law and the expectations of our citizens with regards to the judicial system will be of great importance. On one hand, we have conciliation. On the other hand, we have mediation practices, which will be actually giving us even more power and strength to further improve alternative dispute resolution mechanisms. And the achievements that we have had so far indicate that our sit of time and the rate of settlement is 94% in mediation right now. In commercial mediation, the rate of settlement is 51%. In labor, when you look at the numbers, when you look at the thousands of cases, we see that these numbers are quite large numbers, and they are actually taking away the caseload from our courts, and they are saving time and money. And when we consider all of these facts, we conclude that this is actually a very successful practice. And in the to develop new systems as well with regards to alternative dispute resolution mechanisms, there are actually certain steps that had been developed by our ministry, but we have not had the time to enact them yet into law. So on one hand, we have conciliation, mediation, and considering the how to introduce ADR mechanisms. We will be discussing this issue and we will be taking concrete steps to do this. First of all, what we recognize is that for the public administrations to reach a settlement during the trial procedures, as a company that has some business with the public, certain people may come up and say, why did you settle? What happened? So for those cases as well, of course, by consulting with the president and the esteemed members of the Council of State and talking to the presidents and the members of the administrative courts, and by evaluating all the other actions in resolve all the conflicts before the courts, is actually slowly losing its importance. I mean, without going to the courts, without being in an adversarial position, without having any discussions or conflicts, we are actually going towards Turkey and the world is actually moving towards a period where things will be resolved through by stage about rent, about neighborhood law, about the occupancy or ending partnership, or in similar cases, in the seventh part of the judicial that we will be taking after the elections, we will gradually, step by step, refer the conflicts in the area of civil justice to mediation first, and if they are not resolved through 51% of all the commercial disputes, if they are resolved here in mediation, this is a great achievement. If the 59% of labor disputes are resolved here, and not load of the courts will be reduced, and our judges, prosecutors, and all the members of our judiciary will have more time to spend on their ongoing cases, and they will have bet. We always say this. And of course, regarding both the substance and procedures, all instruments should be used in a timely manner and effective. I also would like to express here that regarding those that apply ADR mechanisms, we will be establishing a new system. We have undertaken the planning, and from now on, mediation will not be implemented everywhere. For them, there will be centers, disciplinary provisions, just like the Ministry of Justice is of duty or abuse of duty, or if there's any intentional or neglect or any unlawful action taken, and if there are any attempts to do so, without any hesitation, we will implement the procedures according to from the profession, including this disciplinary measure. All kinds of sanctions will be applied without any hesitation. Those who do not fully implement the rules, we will implement the rules for them and ensure integrity, and we will be showing all what it means to implement the rules in a full manner. And in the upcoming manner regarding their training, disciplinary, and also conciliators and mediators, their current position is a little bit of a passive. They only listen, they ask the parties to settle if they want to, and they write up the minutes and have them signed by the parties. They are not very much active. But in the new period, the parties to agree to settle and guiding them to this manner, and we are planning to bring them to a more active position, because a passive mediator, a passive conciliator would not be able to soundly manage this process and receive efficient and effective results. At the very beginning, we have started, and from now on, we will change the limits of their powers and we will make the payments accordingly. Let's say that there's been an agreement and conciliation, and currently the payments are made according to legal aid and others, but from now on, in the cases of settlement or conciliation reached, there will be higher payment, and if there is the state of leaving. Parties do not agree and do not settle, and if they do not settle, at the end of the court decision, if the party that does not settle is the party at fault, then the charges will change accordingly. So the mediators, conciliators, and everyone working in ADR mechanisms should work in an honest manner, sincere manner, and with good intentions. And if they have an approach that is not good intentioned, sincere, or honest, we will make manner and we will be taking our steps to ensure this. And I would like to avail myself of this opportunity to indicate once again International Symposium on Administrative Judiciary to improve the effectiveness of administrative judiciary and strengthening the institutional capacity of the Council of State, organized and positive results, and I would like to thank each and every one of those who have contributed with their efforts, and I salute you with respect and Allah's mercy.
Remarks. And now I would like to invite the President of the Council of State, Mr. Zeki Yiğit, to deliver his inaugural remarks. The floor is yours, sir. Distinguished Minister of Justice, distinguished colleagues, the Judiciary Symposium organized jointly by the Council of Europe, the Minister of Justice, and the Presidency of the Council of State. And I would like to say welcome to each and every one of you. As of 2023, we have been celebrating the 155th anniversary of the establishment of the Council of State. For 155 years, we have actually participated in delivery of justice, and I do believe that as members of the Council of State, we will continue to contribute to the Turkish administrative judiciary, as well as the protection of human rights and the protection of the universal values in administrative judiciary, thus being a pioneer in this field for the speedy delivery of the justice system in a just and qualified manner. That are to be resolving the conflicts that occur before them. For that reason, the expectation of justice and the implementation of judiciary is as old as the history of humanity. As it has taken place in the past, in order to meet this expectation as members of the judiciary and to fulfill our obligations as this and is a universal value, and it is actually identifying the right of one party. As Rumi has mentioned centuries before, it is putting everything in place. Since the very beginning of our history, our nation has had a deep-rooted understanding of law and justice for the fulfillment of justice, and it has been accepted as a fundamental value for all societies. And of course, the main aim of justice is to establish justice for all, and that's why all religions have put forward in their agenda law and justice. Of course, justice is one of the commands of God and is one of the aims of religion, and together with the prophets, it has been commended that balance has been brought up to earth. And in the recent periods, we have seen Islamophobic attacks against the Holy Quran. Any attack to the values, the sacred values of that religion, should find its place before justice. And such attacks and actions actually are hindering the tolerance between societies and religions, and is also meaning in that there is a balance of justice. And those who have the balance of justice in their hand should reach correct judgments in a proportional manner. And thus, those authorities, the judiciary and the judges who have the balance of justice in their hand, plays an utmost important role. And it is very clear that this role is of vital value. an instrument and reflection of such efforts, the project for increasing host this international symposium on this project. The project has been continuing for 3 years, and we have now come to the last stages of the project. The solidarity and the sharing of experience that have been exhibited in line with this project, and has foreseen the international institutions to have similar and parallel edition, and it is very clear that all stakeholders have participated in this activities, and there have been certain delays, but by benefiting from the opportunities of the project and technology, we have overcome such difficulties. As the presidency of the Council of State, we focused preliminary on ADR methods, and one of the most important targets of this project on increasing the efficiency of administrative judiciary system. The members of the Council of State have participated all scientific meetings and research conducted in this period, and there have been study visits that have been organized abroad, to which the members of our court has participated. In the project, there have been consultation meetings, a case law reporting and statistics unit of the Council of State. During the preparation of this page, we have participated to the training of our judges with legal reasoning and drafting of judgments, the decisions and judgments of the ECHR and the Constitutional Court, the right to fair trial, and also training modules on the time management for and cases are receiving this training. Under the coordination of the case law and reporting unit of the Council of State, there have been important activities for the codes of case. Will be achieving healthy statistical data, and we will be able to follow the case transfers to the relevant departments and chambers of the Council of State and various other units of the administrative judiciary. Workload of the administrative judiciary and specialization are going to be other topics of this symposium, and the various proposals that have been developed for our country, as well as other possible solutions, are going to be shared. Drafting of measures and legislative acts. Thus, our expectation from all participants is to share their valued opinions with us. As the President of the Council of State, I would like to indicate that we will continue participating in the project activities, and that we are willing to undertake continuation of projects in this sphere. We would like to wish success to the symposium and thank all the distinguished academicians and members of the judiciary, as well as other participants that are going to be contributing. Once again, I wish a successful symposium and a good day. We would like to thank Mr. Zeki, the President of the Council of State. Mr. President, if you allow me, we would like to host you on the rostrum for a brief moment because family photo together with the members of the protocol.
Çok teşekkür ediyoruz efendim. Saygıdeğer.
Thank you very much, distinguished guests. We are now closing the opening session of this meeting. Our symposium
9 dakika mıydı Barkın Bey diye? 9 dakika değil mi? Evet. Tamam. Sayın katılımcılar, değerli misafirler, sempozyumumuz birazdan başlayacak. Sizleri yerlerinize davet ediyoruz lütfen. Teşekkür ediyoruz. Evet, söylediler bana. Teşekkür ederim Gülşah. Salon dışarısındaki saygıdeğer katılımcılarımızı salona davet ediyoruz. Çok kısa bir süre içerisinde oturumumuza başlayacağız. Çok teşekkür ediyoruz anlayışınız ve titizliğiniz için. Saygıdeğer katılımcılarımız, idari yargının
Distinguished participants, we would like to welcome you to the symposium on the International Symposium on Administrative Justice organized under this project. Once again, we would like to say welcome for a closer look at the project. The joint project on improving the capacity of the administrative justice, and it is actually targeting the reforms policy and ongoing analysis towards pilot practices. The project is co-financed by the European Union, the Republic of Turkey, and the Council of Europe, and it has been implemented by the Council of Europe. The Director General on Legal Affairs is the end beneficiary of the project. The Central Finance and Contracts Unit is the contracting authority of this project. The target groups of the project are Ministry of Justice, the Council of State, the First Instance Administrative and Tax Courts, the regional administrative-based approaches to practices, the policies, agree and support and implementation. The second objective is to identify and implement proposals to strengthen the institution's structure and professional capacity of the administrative judiciary. The third aim of the project is to focus on mechanisms and appropriate ADR mechanisms. The fourth aim and objective of the project is to introduce necessary changes to the systems and processes to reduce the length of appeals proceeding by more efficient and effective cases management by the to produce a roadmap in order to provide a holistic framework for the implementation of solutions identified through an in-depth review of the administrative justice system. While developing the roadmap is covering the years 2020 to 2023, it's a living document and it's the first comprehensive document dedicated to the Turkish administrative judicial system. It has been included in the third judicial reform strategy document adopted in May 2019 and the Human Rights Action Plan published in March 2021 and the strategic plans of the key stakeholders. The main node of the first instance courts and the regional administrative courts. To this end, for strengthening good public administration decision making and internal review, there are studies that have been conducted on raising awareness with Turkish public authorities of basic principles of human rights and equality in the Turkish constitution, international conventions, legislation, and of European standards concerning good administration and the Turkish good practice guidelines that is under the preparation. For the same purpose, through supporting the Ombudsman institution as a potential mechanism for the dispute resolution and assessing the value of pre-litigation resolution methods and ADR procedures to the context of administrative disputes, alternative dispute resolution mechanisms will be promoted. Simplification and enhancing the efficiency of administrative trial procedure will be performed through support for introduction of pilot case procedure for group actions concerning administrative disputes, extending range of disputes which may be decided by a single judge and other similar works which will contribute to the reform of administrative judicial procedure through consultation, sessions with relevant stakeholders, the members of the judiciary, representatives of the public authorities. The second area of interest, performance assessment and promotion system, training programs for raising awareness and sensitivity for human rights in the administrative judiciary and application of the European Convention of Human Rights, the European Court of Human Rights and the Turkish Constitutional Court case law more consistently in administrative justice cases, increasing availability of for greater delegation of responsibilities to registrars and the front office staff. The third area of interest of the roadmap is enhancement of quality, performance, and productivity in addition to the main actors of the administrative judiciary. The best practices of the preparation of the guide materials produced by 6 pilot courts actively involved in the project contribute significantly to this process. Besides these, developing guiding sets of administrative and tax court statistics, supporting the improvement of target times in trial process, supporting the work on raising awareness and strengthening international consultations within Turkish authorities. Study visits roadmap is ensuring access to justice and enhancing satisfaction from services. Amongst the most important works to be done are applicable for EU Public Relations Action Plan, especially in pilot courts, to raise public awareness on the administrative judiciary, providing explanatory brochures concerning administrative and tax court processes, and UYAP Citizen Portal and SMS e-notification service to ensure supporting increased public awareness and equal access of all individuals to quality of service. The fifth important area of interest of the roadmap is strengthening the institutional capacity of the Council of State and promoting unity of and harmonization of case law. As one of the most important stakeholders in Turkish administrative judiciary and the project, the Council of State has a key role to ensure case law that has a fundamental impact on the work of the first instance administrative courts and regional administrative courts. Within this scope, it has been envisaged to support the works of the new COS case law, reporting and statistics unit, and harmonization of the case and decision codes of the Council of State with further analysis and recommendations to support the Council of State jurisprudence, thereby reducing the number of proceedings, to raise the awareness of public authorities on the advisory and review functions of the Council of State, and to support the Council of State to strengthen its national and international communication and collaboration effort. The roadmap is introduced pursuant to the project and make recommendations for further reforms with the final assessment report. As a living document, the roadmap will be also updated to reflect the progress made at the end of the project.
Brief information will be held tomorrow. Session, the questions helping you to have microphones. Languages, English, judicial decisions, international and national practice. And we would like to also invite our speakers to talk about achieving consistency of judicial decision-making in the French system, deemed acceptance, simplification of the relations between public and administration under the French law, 2013-1005, distinguished judge from the Conseil d'État from decision-making in the German system. We would like to invite Dr. Klaus Löffenbein, please. To talk about and to present the case law, statistics and reporting unit of the Council of State of Turkey and its impact on the harmony of case law. Rapporteur Judge from Council of State to Turkey, Dr. Zuhal Aysun Sunay. To a fair trial in the light of European Convention on Human Rights jurisprudence and the European Court of Human Rights internal mechanism on preventing divergence of jurisprudence among its sections, we would like to invite the lawyer from European Court of Human Rights, Ms. Zeynep Uçar. Colleagues, esteemed guests, first of all, I would like to greet you all with my regards. Symposium on Administrative Judiciary. The symposium is organized under the European Union Council of Europe joint project on improving the effectiveness of administrative judiciary and strengthening the institution is coming to an end. And the subject of our first panel will be consistency in judicial decisions. And actually, quite my assessment, however, because of the video, it seems like there's not much time left for my speech, but still, without assessment of the subject. When we talk about consistency in administrative judiciary, there are two aspects. The first one is when the court or the courts is over time corrected by higher instances of courts, and also at the same time, in the same time period, the courts of appeal, or even the chambers of the Council of State may have some discrepancies, and for these purposes, unless there are specific ways to eliminate those discrepancies or inconsistencies, we have this possibility of continued inconsistency among the judicial decisions. That is why the lawmaker, with regards to removing inconsistencies, issues, I'm not going to go into the details of these. And finally, I would like to also express that especially after we have introduced the three-instance system in our administrative justice system, strengthen the Council of State's role to eliminate these inconsistencies and to act as the court ensuring case law. And of course, it's very important to ensure the administration of justice, and the Council of State has been searching for such kind of a justice. For me, State was the first instance and the last instance court, and considering the habits that have been formed in that time, the priority and the importance attached by the Council of that would set the case law. Now, any inconsistent judgments from being rendered, and we see that the Council of State is actually moving towards that stage and is seeking ways to strengthen case law unity and harmonization. And for that purpose, we have the relevant administrative regulations as well to make sure that we have this mental transformation in the minds of each and every of our judges, our members, and unless we ensure that, it seems like we will not be our speakers. The first speaker is a member of the Council of State of France, Miss Rosanne Nojalou. I hope I was able to pronounce your name properly. Working as a judge, and I'd like to also share with you that she has been the author of several textbooks on law, and Miss Nojalou will be talking about achieving consistency in judicial decision making, and also the elimination of the tacit rejection mechanism, which is also very important for us. According to our planning, the speakers have a speaking time of 30 minutes. And now I'd like to leave.
Thank you very much, Mr. President. Distinguished President of the Council of State and distinguished Presidents of the Administrative Courts, distinguished judges. I would like to specifically thank each and every one of you, and I would also like to thank the Council of Europe and the whole project team. Talk about two different topics. The first one was administrative judiciary as a whole, and the second one was the relationship between administrative judiciary and the public institutions. Actually, both are in a direct relation. I would like to start with the harmonization, the unity and the consistency of administrative judiciary. This is actually a specific topic within administrative judiciary, because when we look at the administrative judiciary in France, we can say that it is judgment. And we will be celebrating on 8th of February, the 150th anniversary of this judgment. Until this amendment was taken to set up specific sets of rules, and dating back to the Napoleon era, they when you could not find any case law or any, of course, because there was no written legislation or law, this was making things much more difficult. And in order for the distribution of justice to take place in the same manner all over France, this was all over the country. It was not just the Council of State, but we also had administrative courts. And at a certain period, there were even courts under the governor's offices. Therefore, it was not just a single judge, but there were many judges. And today, actually, this is much more valid because this judicial 9 appellate administrative courts in addition to the Council of State, and this is only valid. This is not only valid for France in general, but it's also valid for all the different territories under France. Is special court, which is totally working on parking and also objections to parking fees. When we look at the judicial system of France, it has different material rules and different sets of systems because of the historical reason that I have cited. It's obligatory to have consistency in a very complex legal system. Here, of course, if there is any inconsistency in administrative decisions or judgments, this can create a very major problem in relation to consistency all over the administrative judicial system. I would like to specifically give you certain figures about 2021, and this has actually increased immensely in the first instance courts. Third, in the appellate courts, on the other hand, there are 34,000 cases, and for I'm talking about 2021, by the way. For the Council of State, we can talk about 11,300 case files that have been referred to these. And of course, this large number makes it very important to have consistency, this consistency and harmonization. For instance, equality before law, and the main prerequisite is into two sections. The first one is actually the harmonization, the consistency amongst the administrative courts. And then I will be talking about the consistency with respect to the other fields of judiciary. Now let's talk about the consistency within administrative courts, and let's ask the following question to ourselves. How can we actually make sure that there is consistency even within the Council of State? And maybe we need to start with this question, because the case law, the jurisprudence of administrative judiciary needs to be harmonized. But in addition to this, outside the Council of State, especially in ministries, and there are certain members working in the cabinets of the ministries. In the administrative judicial section, there are 10 chambers, and the cases are differentiated in relation to their subjects, and sometimes there are different instruments that aims at this consistency within the Council of State. First of all, we have what we call a database, actually a database called Ariane. And within this database, we have what we call files of judgments. All the judgments that we call fish are found in this, and this actually covers system the period before even when we started working in the computers, and this is actually an archive that we call recueil. for all decisions and judgments, we check whether this is different from previous judgments or whether this has been a judgment which is in harmony with the previous judgments on the matter. And of course, these files need to be followed, and to pass a different judgment basing on this file, the judge needs to make a registration of this is undertaken by a 3-member unit, which is the unit that is responsible to follow the case law, the jurisprudence. But if is the type of the conflict and it's an extraordinarily important judgment, then this has to be approved by the Assembly of Conflicts, which is the highest council in the Council of State, and the president of this council is the deputy president of Council of State. But of course, we need to pay attention to different levels of hierarchy. Lastly, I would like to talk about another practice in the Council of State for the harmonization of case law, and that is of Troika. Therefore, there is a Troika that is established within the Council of State. The head of the Administrative Judiciary and 3 deputy presidents come together on a weekly basis, and they also check the previous registration of files as to how they have been recorded, and identify if there is any difference with the previous jurisprudence. Therefore, the solution that is adopted by the harmonized chambers, if there is any objection and if there has to be an approval to this objection, then there could be what we call negotiations within this troika. And let's also talk about the unity within the court in general. That is the 42 administrative courts that we talk about, and also the appellate court in the administrative judicial system. And of course, there has to be actually going to be put into practice in the administrative courts. The Ariane, the database that I mentioned, which includes the fish for all the previous judgments, is open to access for all court members and the administrative appellate courts and members of these courts as well. Therefore, the case law of all of these courts with the public, which includes less detail. So you can actually have access to the Ariane database, because legally any citizen in France cannot be eliminated from having access to any court judgment. Of course, they know the judgment. They know what kind of judgment they are at that of the case. You have objected to that is the outcome that and the public prosecutor of that court. In first instance, legal question to the Council of State, a law which is L13. If it's a difficult problem and the conflict here is of various dimensions, the administrative court or the appellate court and this has to be reviewed within 3 months. So this case that has been presented to the Council of State has to be reviewed within 3 months. And the judgment here is not a legal decision, but it's, let's put it this way, if there is a proposal made by the Council of State, the fact that it is not going to be implemented or followed by a first instance court, it is not that probable if the different levels. Even before you make an application to the Council of State, this judicial matter is referred to the Council of State in terms of a question, and you can decisions and opinions of the Council of State are being published in the official gazette, which you can have still access to. All these instruments are indicating what kind of harmonization and consistency needs to be in the jurisprudence of the administrative judiciary, and this has to be tackled from various perspectives. State also has the primary review authority of the administrative judiciary that is reviewing the first instance courts and also the appellate courts. So the Council of State is responsible for the review of administrative judicial mechanisms. And I'm a member of this inspection, this review authority. We go to courts as members of the Council of State, and we conduct reviews on the. We are also responsible for the training of the judges in administrative courts, which is giving us an opportunity to create a common culture. Lastly, I would like to talk about another sociological dimension, which is the harmonization, the unity. There is a member of the Council of State that actually heads these 9 appellate courts. The members of the administrative courts are appointed for a period of 4 years to take part in the administrative appellate courts. And lastly, the deputy president of the Council of State every month, and there is a discussion about the lack of harmony or the problems, and this is an official visit. We can say that this is a very effective visit indeed, and the reason why this is undertaken is that this is strengthening the unity. Talk about the unity within administrative judiciary. Now I would like to pass on to a different area, which is going to be an important area that will attract your attention. When we look at the other tiers and the other instance courts and the unity within these courts, how are we to attain this? Judiciary is referred to a specialized court of appeal and the Court of Cassation. The members of the administrative court are administrative judges, and if there is a topic under their jurisdiction, then the weight is of course, on the administrative judge if it's an administrative matter. If it's about the civil code or other codes, it is under the responsibility of the judge coming from the Court of Cassation. And as of this makes it possible for various other questions to be brought to the attention of the Council of State. So the Council of State is functioning like a filter, and these are actually reviewed by the Council of State, whether this is to give a decision on constitutionality to the Council of State. And of course, there are issues that could be referred to the Administrative Court of the European Union that reviews the discrepancy between the acquis, the European Union acquis, and the French law. Generally, the EU laws that we need to abide by, the legislative pays special attention to parallelism. Therefore, such problems are very minimal. You also asked a second issue, which is not in relation to what we have been talking about until this point, which is the deemed acceptance of the administration. In relation to law change in the French legal system, until this point, principle, but until the year of 2013, this deemed rejection. Therefore, with this new legislation and when with a major change, from this point on, the silence of the administration shall be principally accepted as making the relationship between the administration and the citizens much more simple, and that there could be much more positive replies given to the citizens from the administration. The culture of the silence of the administration was accepted as a deemed rejection. Of course, the legal outcomes of this the party that has made the request, the following was becoming the rule from that point on. But of course, in the legal system, there are always exceptions to the rule. And how does this principle work? You make a request to the administration, and for 2 months, if you do not receive any reply, this means that in principle, your request has been deemed acceptance, is not subject to any notification, and it will be accepted as approved. So there is a period of 2 months foreseen. But this 2-month period to reply by law, I don't want to give into detail, but there are very different examples. Sometimes the deemed acceptance might have to be waited for more than 2 months. If we are to look at the implementation for the deemed acceptance to take place, and certain has to be included in a list on a website as to which areas are under the scope of deemed acceptance. There are 1,200 different cases or hypotheses which foresees different conditions, different and of course, as I have said, there are exceptions to the rule. This law that has been adopted in 2013 especially, it was indicated that there has to be a view of the administration that is expressed, but undertaken in various circumstances, and that's why this list was created. So what are the exceptions? There are the following objections. In relation to the application that you have made, under the following conditions, it needs to be accepted as a rejection. If the demand is not part of a procedure foreseen by a legislative text, or if it is a complaint or an appellate, or if the request is of a financial nature, if it concerns social security, apart rejection. the decisions of the Council of State that have to be also in line with the European international standards, and the as a deemed rejection, or if it comes last year been 1,700 such judgments since 2013. I'm trying to shorten my speech here, but here we're talking about a total amendment of the valid rule, and of course its implementation is extremely difficult. Yes, this new rule is a much more complex rule when deemed acceptance covers is also very difficult. So a positive decision is most of the time not queried or questioned by the applicant, or is not brought to the attention of a different authority. But before, when it was in a very diligent manner, and if it was accepted as deemed rejection, then of course the applicant could make an appeal to reverse this judgment, and this was a method to reverse the decision.
Rosen Noguelu'ya
We would like to thank Ms. Rosa Justice System, and even if I were to summarize the main headings of her speech, I'm sure it would take a lot of time, but I would like to talk about three most important topics. The first one is that in 2021, the number of cases received by the Conseil d'État in France is 11,300, but the number of appeals is an actually difference of 8 or 9 folds. And secondly, the French Conseil d'État, an exchange of visits, there is actually a precaution that they have developed to make sure that the judgments that are adopted are consistent with the case law. I also attach great importance to this that we need to do. And finally, the mechanism that we have always called deemed rejection, we've learned that in France it is applied as deemed acceptance, although there are exceptions. We've heard of this before, but it is also important that we have now recorded this once again in the symposium. I'd like to thank her very much, and now I'd like to leave the floor to the second speaker. The second speaker is Dr. Duffenbrine. After administrative work, starts a legal career at the administrative court, and also carries out academic work in a university, but also in Antalya, with Akdeniz University. We'll be talking about achieving consistency of judicial decision-making in the German system. The time is 30 minutes. Dr. Klaus Löffelbein, you have the floor now. Distinguished presidents, distinguished ladies and gentlemen, dear colleagues, today I have great pleasure in addressing you, as was mentioned by the distinguished president just now. In a really beautiful country, I met my colleagues, I met students, and at the time I actually taught German law. It was very valuable. It's my time, my turn, and today I will be, as much as I can, presenting to you achieving consistency of judicial decision-making in the German system. As was mentioned in the morning session by the President, just talked about 95,000 cases at the Council of State, which is a quite high number. And in terms of implementation, I would like to say that it is very, very ensuring consistency in case law may be even more difficult. So going into my topic, I'd like to provide an outer framework of the uniformity of law. And in large countries such as Turkey, there's a requirement for several courts to exist, and that is why there should be courts of several instances so that justice can be served and case law can be established. And there's a similar first instance, and there are 15 state lander courts. And in the third instance, we have the Federal Administrative Court and Federal Administrative Court. And of course, I will be also addressing the relations between the state courts, which are the second instance, and also the local courts. As you know, Germany has a federative structure as a federal state, as different from law. Among 16 states, among themselves, first of all, ensuring consistency in the case law within the state is ensured by the state, ensuring consistency of case law at the federal level. So ensuring consistency of federal law is the responsibility of the federal administration. The subject matter of the law is reviewed. When we talk about uniformity of law, we see that there's a uniformity of law which goes even beyond the state, the country. Within the European Union, we have the Court of Justice of the European Union, and among the member states of the European Union, they are responsible to ensure that the law is implemented in a uniform manner and renders judgments to this end, and the relationships between justice. When it is up to the European Court judgment, and the judgments of the European Court of Justice are determinant and guiding, and they will also determine the judgment to be rendered by the federal court. So I'd like to go back to the situation in Germany. As I mentioned at the beginning of my speech, in Germany we have the first we say is that a sufficient number of judges should be present, and the judges that are acting should be trained very well. The second instance, they are reviewing both substantial law and procedural law, as make a review of both substance and procedure, but the second instance can only look at the legality of the case. When the case is being admitted into the federal court, only that are addressed may not always reach the third level, the last level. They need to be accepted by the Federal Administrative Court. There should be a permission to appeal to the third instance. And then what happens is that in the first instance, in the French system, but when we move on to the second instance, the number of cases is significantly lower, because even the appeal from first instance to the second instance court rendered a judgment that was different is actually mentioned, but in the application to the appeal court, natural aspect, but regarding the substantive judgment, that could not be corrected. Looking at the number of cases, you may be surprised, and currently in Germany, there are approximately 1,000 cases to court in Germany, so we can say that we are completely at the beginning level. In Germany, there's also this following situation: divert from the case law of the Federal Administrative Court, which may help the law to develop, and there is no consultation mechanism or communication mechanism. The court about 1,000 cases. This is actually something that is not very frequent. I mean, it is also very rare that a court diverts from our judgments. So the permission is given, and the case is admitted for appeal. There is time for an in-depth review. The case law of the court is reviewed in depth, and then we hope, and then this judgment is expected to be also perceived by the lower instance court, because the more judgments that the higher instance court renders, then the lower courts, if the higher instance court and also the Federal Administrative Court renders a very high number of judgments, the topic of specialization will be the topic for tomorrow. But within the German system, in addition to workload, specialization of the courts is also very important. In Germany, although it is not a requirement by law, in almost all administrative courts, there is a specialization in the decision-making or mechanisms. For example, in the Federal Administrative Affairs Chambers, and they also have a division of tasks among themselves. So therefore, indeed, really the specialists of the subject are rendering judgments on their specialized topics, and this is also the same in the lower instance courts as well. But the main distribution of tasks is done by the presidency of the court. And points are actually reduced to the smallest number among the chambers of the Federal Administrative Court and also the chambers of the lower instance courts. If there is a specialization, then we are preventing overlaps. But for example, if one chamber of the Federal Administrative Court to that chamber and then asks them, do you still insist on this judgment? And they ask the question, they consult. However, is taken to the grand chamber, and there all the relevant departments and also the president of the court consider the issue. And even going beyond that, there is also another council that covers different jurisdictions. There are 5 specialization courts. In addition to the Federal Administrative Court, there are social courts, finance courts, labor courts, and criminal justice affairs. And if there is any inconsistency in case law on these issues, then the General Council no. This has actually been present for a couple of decades, but it is very rare for the Grand Council to come together and decide. And it is not every year that the Grand Chamber of the Federal Administrative Court convenes. It convenes every 2 years and renders a judgment. And usually issues actually are addressed. The last issue that was addressed was in summary judgment and also in an investigation judgment. It was an issue regarding the share of costs of experts. So it was a quite detailed grand chamber, and these grand chambers at the state level also convene very, very rarely, and they actually convene even more rarely than the upon the lower instance court, and also the judgments of the Federal Constitutional Court are binding upon the lower instance court's viability. In addition to these overall regulations, meaning that in Germany, in order to ensure of the highest court, there is a requirement to get a permission to appeal, and we have a joint council and grand chamber or such structures are ensured to reduce the caseload in terms of practice or a review kind of duty with regards to the lower instance courts at the local level, or the state administrative court is. Apart from that, in our Federal Administrative Court, the court has 55 employees and also 25 young assistant legal professionals, and sometimes rather than being suffocated by the workload, we actually review the issues at hand in so much detail that we can even go into such details that may not be important for the subject matter at hand. The exchange of views between the courts of first, second, third instance are actually organized in an informal manner. The judges 3 years, a symposium for administrative courts are organized, and every 2 years, what we call a Leipzig dialogue is actually a dialogue that is organized at the Federal Administrative Court, bringing together judges from other administrative courts. What is important, an instrument that we frequently use, is that we have a very comprehensive data bank, and of course the judges have access to this data bank, but also all the decisions that are rendered within the scope can be found in this very comprehensive data bank. And with these thoughts, a symposium will serve to the purpose of further improving law, which is our joint purpose and joint objective. Thank you very much.
We would like to thank Dr. Klaus Pfeffer-Bayer for giving us information on the Federal Administrative Judicial System of Germany. Of course, the number of case files that have been referred to this court, which is 1,000 in a year, when compared to 6 years ago, the fact that we have fallen down to 90,000 is the appeal system. The annual case file that were referred to our Council of State was around 260,000, but now we are very glad this has actually dropped down to 90,000. And if we are going to become a court of jurisprudence, the cases would have to be counted in thousands or 10,000s at most. Therefore, we need to have a filtering system aspects. Hopefully, in relation to developing in the Turkish administrative judicial system, we will be benefiting from your views. Distinguished colleagues, now we have a coffee break. And we have a 20-minute coffee break that is foreseen. So we shall be back here 1:15.
Saygıdeğer misafirlerimiz, birinci oturumumuzun ikinci bölümü için oturum başkanımız Danıştay Başkan Vekili Sayın
We would like to invite the moderator of the second part.
Sayın Başkanım, sözü yine size bırakıyorum. Kolaylıklar diliyorum.
Teşekkür ederim.
Thank you very much. Distinguished colleagues, distinguished guests, we now start the second part of our first session. And now I would like to leave the floor to a member of the Council of State, Associate Professor Dr. Gürsel Özkan. Apart from being a jurist, Mr. Özkan is also a successful academician and has rightfully earned the title of associate professor. So actually having an academic career, and thus he's in need of commendation. He's going to be talking about methods of harmonization speakers, but because we started late and we need to overcome the time lost, we would like to actually ask our speakers to speak 5 minutes less. So from Mr. Gürsel Özkan and Madame Zühal Aysun, I would like to ask them to speak for 25 minutes and not 30. Thank every one of you and say welcome. Of course, my topic is going to be the methods of overcoming problems of unification. After having listened to the presentation of our French and German colleagues and having learned about the methodology there, now we will be talking about how we can overcome the problems of different jurisprudence. In our legal system, Article 1 the fact that the judgments are provided with reasoning is important for our country to overcome differences in jurisprudence, because when we are writing the reasoning of the judgment, the judge needs to foresee the outcome of the judgment, explain as to why they have come up with such a judgment. And of course, while they're doing this, they do more or less a self-review and have the opportunity to review whether their judgment is correct. And also, there has been various other legislation, both in the European Convention as well to the reasoning of a judgment. So it is actually not just sufficient to provide it. It has to be explained with the material and the legal reasoning behind it. And of course, the Constitutional Court, as well as the European Court, sometimes rule for violation because of the right to a reasoned judgment. And thus, it is really crucial to the principle of rights earned in relation to procedure, which is also important for eliminating any discrepancies in the jurisprudence, because the supreme judicial organs, like the Court of Cassation, rights foreseen for the First Instance Court, when the Council of State quashes a decision, a judgment, this has to the judgment of the instance court, because it's going to become finalized after being reviewed again. They need to be very procedure law has brought provisions pertaining to And when there are become a binding rule, which needs to be taken into consideration, but for the Court of Cassation, in the same situation does not apply, because in the law on the civil courts, if the first instance court does not pass a judgment, is a minor detail between Court of Cassation and the Council of State, and of course it's debated whether this is an objective regulation, this procedure, which is not that clear as to why there is a difference between the practice of the Council of State and the Court of Cassation. Again, is also important in relation to overcoming discrepancies in jurisprudence, because when we are talking about retrial, if there are two courts passing two different judgments on the same individuals, this means contradictions are overcome. So according to 53(1)(h), retrial for our legal system is also another methodology to overcome differences in jurisprudence. If there are no legal reasons as to why there could be a different judgment pertaining to the same individuals and the same case, the fact that there has been a judgment violating the previous judgment, there is the institution of appeal in the interest of law, and this is in Article 51 of the Administrative Procedure Law, and it is regulated that the judgment needs to be finalized without having been referred to appeal. So in the application of appeal in the interest to the harmonization of case law decisions, this is the main aim. And the appeal in the interest of law is also another instrument which is to overcome discrepancies in case law. Plus, there are certain decisions of the Court of Conciliation. There are decisions given by the two different spheres of judiciary. This court identifies which court has the jurisdiction and overcomes the discrepancy. But this is only binding for those case files. It's not a general binding nature. And it is only in relation to that concrete conflict at hand, and this is important in relation to overcoming discrepancies in the case law. The fact that we now have the Court of Appeal system, this is Article 3Z Law 25, the Regional Administrative Court, and if there are differences when there are judgments that are of different nature on the same conflict, there could be an appeal case to overcome this discrepancy. This is the main aim, but especially in our legal system, something that does not exist in the continental European law, we have judgments of harmonization of case law to overcome any discrepancy, both in the administrative judiciary as nature, and they are actually binding on all the administrative judicial courts, and that's why they are really important. The decisions of harmonization of case law, their effect is not going to be what I'm going to discuss here, but we can say that they have a prospective effect, important in relation to certainty and foreseeability. And I do believe that there could be different interpretations, and I believe that such unification and harmonization of case law decisions are an important instrument in our legal system to overcome such discrepancies. Plus, there are judgments of the Constitutional Court on violations because we have been implementing the individual application method since 2011, and there are decisions of the Constitutional Court that are indicating how this violation is to be overcome, and it is indicated that there has to be a retrial, and they are of binding nature. they are of exemplary nature, and this might actually create the outcome of elimination of discrepancies. They have only effect on the concrete conflicts. Again, violation judgments of the Constitutional Court is another instrument to overcome differences in the case law and gives us an opportunity to correct this. So, under these headings, previous session by our colleagues coming from abroad, in the federal court in Germany, there is 1,000 case files, and in France, this figure is around 10,000. So the case files in Turkey, when compared with these two figures, is very high. The main reason is overcoming discrepancies in case law is extreme. We have implemented the appellate court system, and we aimed at reducing the workload of the Council of State. But the main aspect is not to reduce the workload, but to actually attain appeal process, and that the conflicts should actually be resolved without being referred to the judicial mechanisms at what we call alternative dispute resolutions. And for this, we need to have the administrative procedural law, which needs to be amended. Take into consideration a hospital and an illness, the fact that going to court and litigating a case is actually an extraordinary measure, and especially when we are talking about the public administration, which is on trial in the administrative, need to take legal decisions based on equal citizenship without making any discrimination amongst the citizens. In this process, we need to take into consideration that there shouldn't be conflicts, and when there is conflict, there has to be a resolution within that public administration. This is my perspective, as you know, and for 11 years now, there has not been one application which has not been taken to court and which has been successfully resolved. So I believe that this needs to be resolved in practice. Also, our distinguished colleague from France mentioned the deemed acceptance as a proverb in Turkish, and that's why if the administration is silent, it is deemed as if they have accepted. There were certain lists for this that were identified in France. So in our country, we need to adopt a methodology of deemed acceptance, and maybe the conflicts will be resolved at the administration stage without even taking this to court. In the continental European system, but in the Anglo-Saxon system, this does take place, and by way of the violation judgments of the Constitutional Court, as well as the decisions of the Council of State, there has to be binding landmark judgments, thus making this an important part of the case law, which is going to eliminate any problem pertaining to the event at hand. The case is equal, and there is no legal norm that is different. There is one judgment for one citizen and another judgment for another. So all eliminate this totally, and we should not actually create any doubt whatsoever. So the problems should be resolved as such, including the individual within the system, and basing our judgments on equal citizenship values to present resolutions. Once again, I would like to say thank you very much for your patience. I actually tried to use my
Gürsel Bey'e çok teşekkür ediyoruz. Vaktini
We would like to thank Mr. Gürsel very much. He actually used his time very well. He talked about 9 different methods in terms of harmonizing the case law and eliminating inconsistencies. And each of these methods, due to different reasons, for different purposes, they can be used. But one of them, most recently, is becoming more and more to the forefront. And maybe as the Administrative Cases Council, we have been using this method results, but I should express that we are actually achieving better results than we had foreseen then. And both our chambers, and also regarding the inconsistencies among the judgments of the regional administrative courts, we are receiving applications, and With regards to these applications, we are actually deciding on these applications in a much quicker way than foreseen in the law and for the chambers of the regional administrative courts, so that we are also in our regional meetings expressing our expectation that we will not be receiving any inconsistent judgments from the regional administrative courts. And I would like to once again thank Mr. Özkan. And now for the Aysun Sunay. Well, Miss Aysun Sunay is actually a jack of all trades. I don't know how to say it, but she is a senior rapporteur judge of the chamber and also the General Assembly. I'm only going to express the Administrative Affairs Commission. She is also working as a rapporteur judge in these councils as well, and also case law reporting and statistics. She is also working as the senior rapporteur judge for this department, and in addition to all this intense work, she is also carrying out academic work. She has completed her PhD degree, and I would like to congratulate her for all the work that she's undertaken. And now, going back to the essence of our topic, on the level of awareness of the case law and the respect for the case law. And now I leave the floor to Ms. Suhal. Distinguished President, first of all, I would like to thank you very much. And distinguished President, distinguished participants, first of all, I would like to salute you all with respect. Ensuring case law consistency, developing case law and disseminating case law that I have been involved since the very beginning of the establishment of this unit. I am very happy to be presenting this paper before esteemed guests in an international symposium, and I would like to express the excitement that I feel. And I hope that this paper will be very important so that this unit will be better known both at the national functioning of the judicial order is one of the most fundamental duties of the highest courts of especially the basic concept, the legal certainty principle. For it to be appropriately implemented, the high courts first of all should generate qualified and consistent case law, and secondly, this case law should be disseminated with a very good governance, and finally, case law consistency should be ensured and maintained. The issue of case law consistency has gained a different dimension. As you would be aware, this has been indicated a couple of times today in administrative justice with the introduction of the appeal mechanism. The appeal courts have been established in different regions of Turkey, and they started as of July 2016, and currently we have 9 of such regional courts. With this new system that has been introduced, considering the fact that many of the conflicts and disputes are actually resolved at the appeal level, it was mentioned that it was understood that an appeal review would not be carried out by higher courts and a case law consistency would not be ensured. This brought Council of State face to face with one of the most important of such measures was, without doubt, the establishment of the case law reporting and statistics unit. Was to strengthen the aim, and that is why this unit ensure foreseeability. Before this unit was established, a commission was established, and this commission was headed and 2 senior rapporteur judges and 1 rapporteur judge. First of all, the case law advisory unit, jurisprudence unit at the European Court of Human Rights, and also the reports and researches department at the French Conseil d'Etat, and also the documentation center, and also legal research and they perform have been reviewed, and also a first in the Constitutional Court, the Arich unit was also reviewed and their legal arrangements have been considered. All of these good practices have been taken into account, but after all, Council of State is an institution of 155 years. It has its own culture and it has its own traditions. So first of all, for its own needs, the Council of State carried out an analysis of its own needs and aforementioned commissioned, and their organizational structure has been identified. The directive on the establishment and duties of the council unit, and then afterwards institutes adding an Article 34A to make a change for the case and its operational activities. These were all regulated in the internal statutes, and after these internal arrangements, the establishment of the case law reporting and statistics unit was a little bit postponed because at the time there was the pandemic, but then afterwards, with the assignment that was made on 1st of October 2020, the unit became actively operational. As I mentioned before, I'm not going to mention all of them, but mainly the duties of the unit are as follows: to undertake regular work to develop case law by following up the judgments to ensure that they are known, and also to make suggestions on preventing inconsistencies in jurisprudence and to prepare statistics and report. The unit is directly reporting to the President of the Council of Rapporteur judges that are working permanently in this unit, and also there are representatives that are selected from each chamber, and we work together with them in carrying out our duties. These are very important for us because they are also carrying out their duties at the other councils and the chambers, and in that way we are able to capture the jurisprudence dynamics in a minute are being carried out through our representatives. And also we have a bureau carrying out the secretariat work of this unit, and they've been working with great sacrifices for the last 2.5 years. They used to be working as the judgments and the dissemination of judgments bureau. We have one director of the bureau, 8 staff members, and also 2 statisticians who are working in this unit. Moving on to our activities, undoubtedly the most important activity of the case law reporting and statistics unit would be the publication of the judgments. Publicizing the judgments is a very important. It is absolute that disseminating the judgments of the Council of State by using good methodology and making sure that they are understood in the correct manner by everyone would be well-made judgments, filing the court cases in the right manner, concluding the cases in a short period of time, and the confidence in the judiciary. This issue was actually there was a decision to prepare a directive to prepare the judgments in an anonymized manner by clearing of personal information, and the relevant work was made. And on 6th of February 2019, the directive was actually published on once the Bureau became operational. First of all, anonymized and cleared them of personal data with regards to the judgments that had been published so far, but there was the one basic principle: only the judgments that were identified by the chambers or so there was a need to undertake a new measure and undertake a new arrangement. And after distinguished president came into office, there was a prioritization, and on 25th of December 2020, a new directive was published on the publication of the judgments of the Council of State. And according to this directive, it was mentioned as a principle that all the judgments rendered by the chambers and the councils of the Council of State would be regularly published. So it is not only the judgments that are indicated in the directive, for example, such as the stay of execution, are anonymized, they are being publicized. And of course, after they are published, the number of judgments that have been published increased quite drastically. Before the operation of the unit, a total of 24,264 judgments had been published. But after this directive, the number of judgments that are publicized increased very rapidly. And even in 22, the number of judgments that were publicized were 60,000. And I learned that currently there are 152,000 judgments that are publicized on the website of the Council of State currently. Another important activity of this unit is to prepare the annual reports. And according to this activity, the annual reports for 2020 and 21 have been prepared and publicized and distributed to the relevant units. And currently we are preparing the annual report for the 2022 year. And these annual reports, in terms of their content, first of all, they start with general information about the Council of State. We also include the speeches that have been delivered by the President of the Council of State, and also all the other issues, elections, workshops, symposia, training, international relations, all the developments and activities that might included. And another important part for me is the statistics and the landmark judgments that are important. And in the statistics part, we try to actually creating the backbone of the annual report are the landmark judgments. And we actually identify these judgments by talking to the relevant representatives from the chambers and members and the councils that year, and they are then classified according to their subject matter. And in this way, we are, in a sense, developing an institutional memory of the Council of State. Important events that year are actually written down in history, and also by publicizing the important landmark judgments that have been rendered that year are ensured to be better known by others, and we are creating a compilation of important judgments. So these are distributed physically and also publicized on our official aspect of our work is the bulletins for judgments. Yes, it is very important that the judgments are anonymized and publicized on the website, but this is not sufficient. May not be always possible to select the right judgments from the pool of judgments. That is why, in a systemic manner and under thematic headings, we are creating the bulletins for judgments. In 2021, for example, all the judgments that have been rendered by the Council of Unification of Case Law was also created in a judgment bulletin, and also because they are relevant for all the members of the judiciary have been rendered upon the request. Stamp taxes and charges was the topic covered, and another also they have been designed to make sure that there's an access to the actual judgment itself. Another important, as we mentioned before, especially after the introduction of the appeal mechanism, the importance of jurisprudence meetings was once again recognized. And actually, since 2012, we are actually carrying out all these activities with the relevant courts. But after 2021, we have changed the concept of the meeting in 2020, correction. Before 2020, we were carrying out a study visit to the relevant regional administrative court, and we would be replying, taking questions from them, and we would be visiting the relevant region together with the distinguished members of the court and organize meetings and answer their questions. However, before the meetings, first of all, in general, one administrative topic and one tax-related topic is identified, or there could be a certain subject matter that is identified for the meeting, and then after the topic is identified, all the heads of the chambers in all the regional administrative courts all over Turkey that are dealing with the subject matter or disputes relating to the subject matter are contacted. And if they have any questions and after we receive this information from the relevant chambers, then we convey the questions and requests to the relevant chamber here at the Council of State. And the relevant chamber, first of all, work on this issue. And if they would like to share a certain piece of case law or a piece of information to the relevant regional administrative courts, they identify them. So we are actually creating an agenda through the cooperation of the relevant chamber here at the Council of State, and also the general report is prepared at the end of the meeting. The first meeting was held in Istanbul in 2021. Regarding disputes that arise from the zoning legislation and also disputes that arise out of and that was relating to full action cases and disputes that arise from the stamp tax and charges law. And finally, in Ankara, a meeting was organized, and in the meeting in Ankara, the disputes regarding the measures taken under the state of emergency was the topic, and this was the last case law assessment meeting we held. And it was very important for us to have a concrete conclusion as a result of these meetings. So the conclusion reports that have been prepared as a result of this meeting, they are sent to all the regional administrative courts and first instance administrative and tax courts using the UYAP system, and we believe that it is leading to very important. Actually, so far I have been talking about the activities relating to prevention of inconsistency in case law, but we are also supporting the activities to eliminate in chambers. Again, among the judgments of the chambers, or between the two chambers of the Council of State, or between the councils or the chambers, if there is any inconsistency in case law, we are asking them to identify them and report them to us.
The report and convey this to the President of the Council of State. The last report was prepared in 2021, and it was actually referred from by the President to the Board on the Harmonization of Case Law to have already established, understand the past in a very effective manner. And so statistical data that was and the other come across to is entry of data. Therefore, now we're working on really fundamental issues. If we can establish a good both annual as well as quarterly statistics, which are more limited in nature, which are published. As I have also mentioned, for the statistical activities, we are working closely with the various institutions. There is a protocol that we have signed with the Ministry of Justice, the Judicial Record and Statistics Director General, for the sharing of data and the processing this data. This was actually a live screen that we planned of this symposium, as well as the Council of Europe and the project on increasing the efficiency of the administrative justice, as well as the strengthening of case files, as well as judgments. And this was about the harmonization. And under this particular activity, we have really conducted important activities. Of course, data entry is really important. So in line with this, we have actually established a council for developing of case file codes. And up to this point, the problem for the case file codes was the administrative courts and the tax codes, and the codes that they were using in the first instance courts and the codes in the Council of State, they were different. So when you are naming a case file, to one point it was similar, but the name or the case file number was changing in the Council of State, which was making our work for obtaining statistics, identified experts of the area, to professors from Ankara University accompanied us. Again, in the specific council for developing case file codes, there have been colleagues representing in the various administrative and tax courts, plus the Secretary General, and also the senior actually requiring a very detailed activity. So on 1st of April 2022, Antalya, there was the organization of an agreement with the administration act so long on this aspect. We do hope Council of States state will have an aligned code system that could be consistent all throughout the prosecution, and to obtain healthy statistical data to establish an infrastructure for that, as well as following the prosecution and coming activity. And it is actually an activity that concerns all of the administrative judiciary, which is about to be finalized. Whilst amending my remarks, I would like to indicate that our unit has been functional and operational, and also the sharing of the judgments of Council of State judgments with the public opinion, the annual reports and the principal decisions, preparing the thematic bulletins, the meetings for harmonization of case law, and there have the material, and we have referred this to the attention of the relevant professions. And we have actually become more institutionalized, and it's really important for this unit to be strengthened, so that the role to me, ladies and gentlemen, and for your patience. We would like that since the beginning and establishment of the case law statistics and reporting unit, she systematically shared information on this unit with us. Actually, this unit, in relation to the function that they fulfill, is one of the most important units of the Council of State. And I would like to thank once again her for her presentation, and we would like to give the floor to our fifth speaker of this session, Madame Zeynep Uçar-Tagnay, participated in the opening ceremony of the judicial year for the European Court of Human Rights. After having met with the Turkish judge, Madame Saadet Yüksel, we had an opportunity to meet with the division on Turkey, and on this occasion I had an opportunity to see that we have really very accomplished Turkish jurists in the European Court of Human Rights. I had an opportunity to meet with her last Thursday, and today I'm really happy to be in this symposium. Today, her presentation will be in consistency of case law under the right to a fair trial in the light of European Convention of Human Rights jurisprudence and European Court of Human Rights internal mechanism on preventing divergence of jurisprudence among its sections. Now, I would like to leave the floor to Madame Zeynep Uçar-Tagnay. Thank you very much, Mr. Chair. I'm really happy to be here. First of all, I'll be talking on two aspects. One is in light of the case law as to when the diverging decisions lead to violations and when they do not. And also in the short section of the presentation, I will constantly talk about the court. Of course, when I say the court, it's the Strasbourg court. And there are many applications, and I actually need to say that we receive a lot of applications on this, but the applicants are not always happy as a result of their application. Sometimes the court might not lead and come up with a judgment that they expect, to a judgment of violation, and of course the grounds for violation. So this is not a topic that is clearly understood from both sides, and maybe I can start by this. First and foremost, we need to underline the following: the interest, the legal interest that the court protects is legal certainty and foreseeability and the state of law. And while this review is being done by the court, this is actually an atypical review. they do not limit their activity to as to how the court has made this actually come up with that. The standard in relation to discrepancies is actually a minimum standard. The Council of Europe consists of 46 countries, and the minimum measures that are needed to be taken. But in domestic legislation, of course, there could be even more remedies and precautions that could be taken. Today, I will be talking about these minimum measures and remedies. First and foremost, when is there a discrepancy in the legal sphere? Some differences in the conditions, and of course at this point the court does not approve this as a discrepancy of a certain level of disability. The compensation that has been ruled for him is actually lower than the compensation that was ruled by another applicant. This was deemed to be inadmissible because when you compare the court judgments, although the legal norm is same, because there are certain differences in the case, the court has indicated that there is no discrepancy. For courts to diverge from the case law or an involvement, and the applicants, for instance, they actually indicate that the judgment for them is different, and that this is creating discrepancy. But the fact that of course, there is no discrepancy in the case law. This is not a right. The only right foreseen is that there has to be reasoned judgment. And if there has been a different judgment when compared with the case law, it could be different in each and every. But most of the time, when we look at the applications in Turkey, and I can talk about some judgments, the applicants have indicated that there are contradictory judgments, but the court has indicated that there has not been any contradictory judgment, but has seen a violation. And the most typical example is actually Ener Boyraz versus Turkey, and the other one is Hülya elaborate further on, is that for a case law to be contradictory, in addition to being on different sources, there has to be an in-depth analysis. This criteria, of course, the differences in case law does not need to be numerous, but if we have a case law on various aspects, this does not on its own lead to a contradiction. But in these two cases, in Emel Boyraz and the others, the interpretation of the Council of State may not be seen as binding, but it has been seen in violation in relation to the correction of ruled against the applicant. The fact that they sit in the panel of judges, and the fact that they know the case but still they have not provided any reasoning, has meant that there has been a violation. In addition to this, there are certain legal instances. For instance, there is a new legislation, and there is no if they come to the European Court of Human Rights and criticize that there are contradictory judgments, this is mostly going to be found inadmissible, because this newly arising legal situation in relation to interpretation, the courts require time, and they require also time to harmonize the legislation, and they can accept this as necessary. Of course, the timing is important. There could be an application. For instance, there was an application at the court in 2010. After this application has been done, and the government was notified, The government has stated that the court is going to resolve this with interpretation, and if the government provides scope versus Czechia, which could be a judgment. When is there a contradiction? When we talk about the judgments, when there is no harmonization, and because of such a reasoning, maybe because the judgments of the Court of Appeals is final and they're not open to review by Council of State, or they're open to review, but the Council of State does not have a determined case law. They have put forward this determined case law, but the regional admin courts and first instance courts are not following. So the court is going to identify that there is a discrepancy, there is a inconsistency in relation to this. So in addition to this, maybe we can talk about contradiction. Or there's no contradiction when it comes to another court during this review, both within the relevant unification amongst the various chambers of the Council of State. This will be also identified as an inconsistency. Again, another example, the judgments of the Constitutional Court, although they are binding on that individual application, the identification that have been put forward by and implemented so that there is differences in case law, the court is again going to identify that there's an inconsistency. The last example, which was subject to a grand chamber decision, different sections of the judiciary, the Court of Cassation or the Council of State. This will again be interpreted as an inconsistency. That is not enough because having made this identification, this is not just going to make a violation for Article 6. Then they're going to check whether the differences and the inconsistencies in case law are in-depth and they are prolonged. When is an inconsistency deep or big? If the courts are actually making different interpretations, in some applications, if they review them, seeing this in their jurisdiction, but some others they neglect. So this is actually a profound inconsistency because it automatically affects the outcome. Plus, comments on the duration. This is also a profound difference. Or individuals, for instance, public officials or disciplinary cases that concern a large number of individuals. When there are cases that implement different rules in relation to the merits of the case, this is also a profound inconsistency. When we're talking about long-standing, is there a magic period? No, definitely not. The court identifies this one by one on the specifics of that case at a given period. If there is any requirement or there has been a lot of cases because of a social necessity, and the court, whichever court is going to identify the case law acting in a speedy manner, has not even put forward the principles, even one opportunity to actually harmonize the case law. This is the question that needs to be answered, and basing on this criteria, if this is a profound and a long-standing inconsistency, then the court will refer to criteria number 3 and identify that in this case, the mechanism that is going to actually review the differences, the inconsistencies in case law are going to be tackled. It's not like there shouldn't be a difference in case law at all, but if there is such an inconsistency, it needs to be remedied as soon as possible in the most effective manner. Let's assume that there is no mechanism. In some of the judgments pertaining to Bulgaria and Romania, the court identified that such a mechanism was not even seen and foreseen in the law, and that's why ruled for violation of Article 6. Again, continuing from Romania example, the Grand Chamber judgment of the church, the Greek church, Pupenic judgment. This was about a property case for the distribution of the property belonging to the church. Here, the Supreme Judicial organs gave so different judgments, and sometimes even on the same day, which led to the discrepancies and inconsistencies in case law, leading to the first instance courts. There is actually such a mechanism in the law on Romania, but maybe those mechanisms were not operational, and that's why there was a violation on Article 6 identified because of this inconsistency. Another example, or fourth example indeed, this is actually courts do not take this into consideration. So there is maybe a decision of unification of an harmonization of case law or a constitutional court judgment, but this court judgment is not effective. It's clear that there is, of course, a minor tolerance, but if the inconsistency continues despite this, then again this leads to a violation. Another aspect is there is a mechanism, and when there is a final judgment on the applicant's case, this has not been operational. It has been operational immediately afterwards, so there is no effect on the applicant's case. Here, in this instance, this is a very atypical review. The court is going to rule for non-violation, because here what is important is there is one principle, very simple. The legal system is going to make the instruments they have in their hand in a rapid manner, respectively. In the mechanisms, we also need to make the following explanation. What we mean by mechanism is, of course, we have a lot of states, and it's not like making the mechanism of each and every one of them a standard. So the names could be different, or the traditions could be different. And maybe in some legal systems, they wouldn't need this, because one decision of a chamber, grand chamber, is binding on all. So what is important is for the mechanism to be a general mechanism. Therefore, what we call extraordinary measures, or extraordinary appeals, or the appeal in the interest of law. If it's only on the applicant's case, the Court of Human Rights does not see this extraordinary mechanism as an effective mechanism, because it is actually contradicting with the legal certainty principle, and at that point this mechanism is not deemed to be a sufficient and an effective mechanism. Our fourth aspect is when there is inconsistency, a profound and long Perihan Şahin Grand Chamber judgment versus Turkey, where there are two different branches of the judiciary that are not hierarchically linked to each other. The fact that there is no mechanism to overcome this inconsistency does not violate Article 6, and the Convention cannot bring such an additional responsibility. Interpreter can actually have a dialogue in time, and thus this is not violating Article 6. So the incremental.
So what I wanted to say is, maybe I can repeat what I said at the beginning. What the court seeks, independence of the courts, but to ensure legal certainty in the legal system, to make sure that the existing mechanisms are operating in a fast and effective manner. So the European Court of Human Rights, which is an international court, to what extent can the court do this, and what are the mechanisms that exist at the court? And this is what I'd like to address right now. This is quite the opposite. The European Court of Human Rights thinks as follows: I should prevent any discrepancies in jurisprudence because eliminate tolerated. That is what the court thinks, and that is why the mechanism is completely based on prevention. And this is actually new. And actually, since 2001, this department has been established, and it is a department of 21 years, and it's actually not that new. It is quite old. It has a history of 20 years. The name is Jurisconsult, but this has been translated into Turkish as Counselor for Justice, and I don't think that it is correct. I mean, it is actually that has been appointed, that who knows the court very well, and then had an assistant later on. But after 2010, there was a conference in Interlaken on the future and the reforms that need to be undertaken by the court. And the contracting states requested the court as follows with regards to admissibility criteria and the jurisdiction of the court. They demanded the case law to be implemented in a more uniform manner, and they asked the parties and also brought different suggestions, and some of those suggestions can be found in protocol number 15. So what is the Jurisconsult department? And it is actually similar to the department that has been established here at the Council of State. It's a difference, and maybe this is an advantage of being in the same court and not having so many employees, meaning that we have regional administrative courts all over Turkey, and also the instance courts, and the Council of State is also a very large building. But there at the European Court of Human Rights, there is a much tighter kind of work. And the Jurisconsult, before the chambers, the panels of 7 judges, before they review the cases, first of all, they collect all the agenda, present any suggestion, but if a very new topic is to be discussed, they could provide suggestions saying that this is a new legal situation and the court has not covered this in its jurisprudence, first of all. So first of all, presents this fact to the chamber and then may suggest them to refer this case to the grand chamber, or if the draft is not in line with the jurisprudence, the attention of the chamber. And also, it does not only suffice with these. If there are certain international standards that should be applied at this court and at this case, and actually we see this in many of the judgments of the European Court of Human Rights, that is actually the product of a very well experienced research team. They may compile all the international so that there is no different case law which emerge, especially among the different chambers. As you know, there are different formations. We have judgments of a single judge, and these are rendered in the files which are manifestly ill-founded or inadmissible, and there are also the committee judgments, either substantial or inadmissibility. Have to refer the case to the chamber, and usually the practice and the tradition is to follow this. And the chambers are composed of 7 judges, and the most important judgments are rendered here. They convene every week on Tuesday, and Jurisconsult provides them great support with regards to jurisprudence. And the Jurisconsult has another duty. As you know, the judgments of the chamber that are rendered on the basis of substantial cases, the applicants, the government, can appeal to the grand chamber, and the rate of cases being taken and appealed to the grand chamber is actually very small. I mean, if there's a new context, for example, or a problem that emerges which has not been considered with regards to that article of the convention, or maybe within the established jurisprudence of the court, the applicant or the government may claim that there is an inconsistency among the jurisprudence of the chambers. And in that regard, the Jurisconsult entered into force after the adoption of the protocol number 15 was that if the chamber believes that this is a new legal situation brought before them and this issue should be decided, protocol 15, in order for them to be able to do that, they should have asked the parties, can I send this to the Grand Chamber? If one of the parties objected, and usually the governments objected to it, even if it was a new legal issue. And the protocol number 15 lifted this condition of asking the parties for their consent, and from now on the chamber may use their discretion to send the case before them to the Grand Chamber. And in that case, the jurisconsult has a very important role because in 2022, it is a much larger department. There are full-time legal professionals, but also in the chambers, there are rapporteur judges or other legal professionals who are supporting rapporteur judges, and there are certain jurisprudence. They can predict and foresee where there could be a divergence or inconsistency, and they present it to the attention of the judges, and usually the judges follow them up. Of course, they have their own discretion as per the independence of judges. To not follow up the suggestion, but that is another role that they have. Without further ado, I actually would like to talk about another topic. There is all committee judgments, the rulings of the chambers, the Grand Chamber in the original language that according to which article or which subheading. There's a small box. We ourselves, for example, the professionals working in the court for knowledge sharing, document, and this platform is a living platform. Articles, Article 2, Article 6, Article 4, and when you click on them, you see the most recent judgments with a very brief summary. And apart from that, there are some guides relating, possible to find them there, and there are also thematic others, for example, on issues relevant for Article 6, for example, on labor just relating to environment. So both the guides and also the knowledge sharing platform. On the practice side, this is all from my side. Thank you. We would like to thank Ms. Zeynep very much. In Strasbourg, at the court, when we were being introduced, our Turkish judge, Ms. Saadet, used words of praise regarding Ms. Zeynep. And today, she has shown us that these were not only words of courtesy, and we would like to thank her very much for the first one is that for the inconsistency of case law to lead to violations, they should be profound and long-standing. But of course, the European Court of Human Rights, when there's a judgment that is against the case law because they saw and they know that it is not possible to correct them, they have developed mechanisms that would prevent discrepancy in jurisprudence. I'd like to thank Ms. Zeynep very much. And now we have completed the first part of our panel, which was relating to the presentations. And now we have started the discussion part. In the discussion part, we question to Dr. Klaus Löffelbein, and I'm going to ask him to clear one point where I am hesitant about. And that is the fact, you are listening, right, Mr. Löffelbein? You mentioned that the first instance courts are reviewing both in terms of substantial facts and also legality as well. But in the second instance state courts, you mentioned that they are not reviewing from a substantive law point of view. That is what I have noted down, and I would like to check whether I have understood well. Because that is not the case in Turkey. Is that really the case, or did I misunderstand? I am kindly asking you to please explain, and after that we will be expecting more questions from the participants. In Germany, as is the case in Turkey, we have the first instance and second instance courts where legality review and factual review is carried out. So from both a substantive aspect and also legality. That corrects my misunderstanding. Thank you very much. So the translation indicated that in the second instance there's only legality review. So apparently there was a translation mistake. So this has now been corrected. So we have now started the questions and answers session. Do we have any participants who would like to ask a question? If you have any questions, could you please phones are available. Distinguished President, from the Istanbul Regional Administrative Court, I'm the President of the Court, Ahmet Çelik Yılmaz. My question is to the French judge, our dear colleague, and also to our German colleague. What I am curious about is, both in France and in Germany, regarding the in-service training of judges, do you have a detailed program? Everything that has been explained are relating to human resources, but in order to increase the quality of the judiciary, how do they implement in-service professional training for the colleagues that are actively working? Thank you very much. So I first leave the floor to Ms. Rosen.
La formation des membres des juridictions.
Regarding the administrative courts or civil or criminal courts, the training of the judges is provided by a special unit where we provide training, circular trainings. I'm not talking about, of course, the first education with regards to law, but there is a continuous in-service training. When the judges are appointed, they first receive a training, and regularly the Council of State is providing the service, which is a very important training. As you mentioned yourself, this is very important because, of course, this contributes greatly to the consistency of case law and administrative justice, and in this way we make sure that they all have the same perspective, and we are ensuring the unity of a group of professionals, and also making sure that all judges have access to the database such as REM, and also they are receiving further information about case law. Yes. Thank you very much. The situation in Germany differs in the sense that the Federal Administrative Court on this issue is not authorized, meaning different cities we have an academy of judges, and this academy of judges are providing in-service training programs more for younger professionals, and also within the federative system of Germany, both from the federal level and also the state level, are organizing and operating a joint academy, and experts coming from different places, lawyers from different places, and also the legal professionals, practicing legal professionals, take part in this Academy of Judges. Apart from that, in a more formal education setting, such kind of an education is not provided by the Federal Administrative Court. Within the framework of the Leipzig Dialogue, actually, we have achieved very good results, and the number of judges who attended was actually much more comprehensive, and we've seen a higher level of participation, and working groups are created where different topics are addressed there, and this could be considered as a form of in-service training. Thank you very much, Dr. Klaus. Any other questions? Please, already underlined, statistics is a science on its own, and as judiciary, we have been distanced to this branch of science for a very long time. In Istanbul, at the end of every year, when we were issuing annual activities of the judgments of the regional administrative courts or the first instance courts, and we are identifying what is missing in the deficiencies of the first instance courts as opposed to the chambers. And this gives us very important data. For example, in the and the returns indicate, for example, it gives us an impression on that court's number 7. Thank you very much for this question. Currently, we have not undertaken such work so far, but actually this is due to the issue that I raised before, and this means that there are different data entries at the regional administrative courts, regional tax courts, and the Council of State. If we can ensure harmony in terms of all these different levels of judiciary, we will be able to get these statistics. And also, we do not have consistent and sufficient data entry yet, but in the way that you have mentioned and in various areas, obtaining statistics indeed will be important to generate judicial policies and to take necessary measures. Currently, as the statistics units, we are actually able to obtain data in the way that you have mentioned, but currently we are not able to undertake that work due to the data at hand. Thank you very much. Ms. Rosen wanted to take the floor. You have the floor, madam.
I think it's very important, and so the French Conseil d'État also has an annual report, and in its annual report you have all the statistics, so you have all the numbers. I agree, it's a very, very important thing to know exactly, well, the number. I should speak in French maybe. Le nombre de dossiers, le nombre d'affaires qui arrivent, le nombre d'affaires jugées. Quels sont les domaines? Which are the topics?
Statistically, how many cases there are, in which area these cases are being tried, and also, for example, does it usually quash the judgments or unit as an annual report? But I believe that all this information is very important, and this helps us understand how the judiciary functions. Thank you very much once again. You have the floor. My name is Alperen Çıtak from Hacı Bayram University, member of faculty. I have a question to Ms. Rosen. In the French Conseil d'État, Commissaire de Gouvernement, it is now called Rapport Public. What is its function in ensuring consistency in case law? Because these rapporteur publicaires are actually working like institutional memory. I'd like to receive some information.
It's been actually a very good question. Yes, in the administrative courts and the administrative appellate courts in the Council of State, we have what we call the public rapporteur. And now the name has changed. And before it was the Counselor of the Government, and now it was changed to Public Rapporteur, and it has become much more independent from the government. But the role they play is if the case law is in line with the landmark judgment, they notify this, and if there is a changing judgment, they actually report why this change in the case law has occurred. And these reports are really very beneficial for the archiving as well. Of course, in relation to the decisions, here the judges, by the decision of the public rapporteur, but this is identifying a tendency, what has been the tendency, which are landmark judgments, and which are still landmark judgments that are valid. And it's a very valuable resource. And in the administrative judiciary judge. Thank you very much. My name is Mustafa Nafiz Acar. I'm a member of the 8th Chamber of the Council of State. My question is to Madame Zeynep. In the 2000, we actually received a concept from the ECHR, exaggerated implementation of functionality. If the administrative judiciary does not see this as it's under their jurisdiction, they would actually deny this and send it back. What are we going to do with these case files? There is no petition specific to administrative judiciary, so we were actually sending it to the ordinary judicial system. This was taken to ECHR, and the European Court of Human Rights indicated that in such there should not be memoirs of one of the judges for Turkey. It was indicated that it was given before the European Court, the European Commission on Human Rights, and now such judgments have also started occurring before the European Court of Human Rights, and now such judgments are not taken that much into consideration by the European Court of Human Rights. I would like to learn what is the last status quo about this. As a criticism, you are right. As you know, we have Rule 47, which is the rules for the application form, and we actually find some and many of the applications inadmissible, the way the allegations are expressed in the application form, etc. But in my opinion, the European Court of Human Rights should not be directly compared with the national courts. They're all different areas of jurisdiction. We only look at the application from the human rights perspective, and only 8% of the applications are reviewed. A great part are actually found inadmissible, and the main reason is either the assessment of the national courts are sufficient vis-a-vis the convention, or the applicant is treating the European Court of Human Rights like that the court is making the application to the court more difficult, the passing from the admissibility all the way up to the review on merits. There are many reasons, and the reason is that the member states they cannot resolve certain aspects on human rights within themselves, and they're actually pushing the ball in our court. And of course, this court has very limited capacity. We do not have sufficient number of jurists. We have a given number of budget. Analyzing all these case files one by one is like a very dire situation. The court could have actually made the following, that reviewed applications, all applications, without actually bringing limitations. But in that case, the major issues were going to be lost among them. La Cour qui compte, the court that counts. And that's why we want to be an important court. And sometimes the system has changed, and even the applicants do not remember the case. So we would like to be the court that prioritizes the most important cases and transfers the others. Thank you. As foreseen, we have come to the end of today's agenda. It's been a very productive and a very good meeting indeed. I really benefited from the remarks of our distinguished speakers. So I now have to close the session, but I would like to end it by saying a few remarks. Of course, this unit for statistics is recent, and we have just started receiving statistical data, but for some time we have been keeping certain statistical data, and the main one has been how many files we received, how many we have cleared, what is the pending cases. Today we learned that these statistical figures 6 years ago when we were actually reviewing 260-something thousand case files, we are now reviewing around 95,000, but the examples we have before are 11,000 and 1,000. So this is showing us that we really have a lot of ground to cover. If we are going to be a court of jurisprudence, of case law, we should distance ourselves from reviewing the material facts of the case. And we need to focus on the limited number of case files. And for this, we need to take the French Council of State Conseil d'État for 11,000 cases a year. Hopefully, we can undertake such reforms. Once again, I would like to take this opportunity to thank each and every one of you for your interest, and also to our speakers, to our guests from Germany, from France, from the European Court of Human Rights. We would like to thank them very much. Again, I would like to thank our colleagues from the Council of State here and wish you a good day and a token of appreciation ceremony. We would like to thank the moderator of the session, and we would like to present a token of appreciation. So, first of all, I would like to invite the Director General on Legal Affairs from the Ministry of Justice, Mr. Hakan Öztatar, to deliver the presents to our guests. And I would also like to invite the acting president of the Council of State, Mr. Vural.
Danıştay üyesi Doçent Doktor
Mr. Gürsel Özkan, Associate Professor from the Council of State. Senior Rapporteur Judge, Dr. Zuhal Aysun Sunay. We would like to keep Mr. Öztatar on the rostrum for a brief while so that we can have a family photo. Now we would like to invite the Secretary General of the Council of State, Mr. Kemal Açıkgöz. Madam Rosa Nugulu, could we please invite you to the rostrum? Judge of the German Federal Court, Mr. Laffenbein. In Court of Human Rights. For this session, in memory of today, thank you very much.
tüm katılımcılarımıza sonsuz
Thank you very much to all our distinguished participants, distinguished guests. We would have come to the end of the first session on the International Symposium on Administrative Judiciary in the context of the project on strengthening the administrative judiciary and the institutional capacity of the Council of State. Tomorrow we're going to be talking on the reduction of the workload on specialization with 2 further sessions. We would like to thank each and every one of you. One last note, could you please remember to drop your headphones and good evening.